Good afternoon and welcome to our Tuesday webinar. We're here with Matt Grumbling. He is a patent attorney. Today is the last in the accessibility series. So today he's going to be talking to us about accessibility remediation. So what to do if you are violating ADA or if you're accused of violating the ADA. So actually very important information that everyone should know. Hi, Matt.
Hi, how you doing, Julie?
I'm great. How are you?
I'm doing well. I'm ready to go here.
All right. Well, take it away.
So, for those of you who've been following this series, you may be ready to breathe a sigh of relief. Today we're just putting in our last installment of this series. Again, my name is Matt Grumbling. Here's my email address, matt@ntiplaw.com. That's NTIP for our clients. They like to shorten it. It doesn't everybody. What I'm going to be talking about here is, this is kind of the short, pithy statement, accessibility remediation. I tried to keep it down to down to 2 words. What we're going to be talking about here a little bit is, what you can expect if you're accused of violating the ADA. So what we're going to be talking about here, I'm going to do a little bit of a recap of the ADA, what it is, and then I'm just going to talk about, what the ADA complaint will look like. And there are 2 different avenues of an ADA complaint. One is a direct filing with the DOJ, which is fairly simple. Well, I'll go over that. And the other one is a private civil suit, which is usually filed either in federal or state court. And I'll talk about federal procedure, but for the most part, like for instance, if you are sued in the state of Arizona, the procedure in federal court and state court, that they're practically the same. So let's just do a quick recap of the ADA. It's an Equal Opportunity Act. It was modeled after previous Equal Opportunity Acts like the Civil Rights Act of 1967. It is considered remedial. That means that courts interpret it broadly, which means that if there's any question of whether something comes under the ADA or not, they're going to lean toward including it under the ADA. So if you think you're going to get out with a technicality like, oh, they forgot to put this word in there or something like that, yeah, probably not. Courts often fill gaps in the law with non-governmental standards. We saw that a couple of weeks ago when we talked about web-based ADA compliance, and we noted that the Department of Justice really hasn't done anything, although they're tasked with passing regulations in the field. They haven't really done anything to pass regulations. They've rattled their sabers a little bit. Not quite sure why they've backed off of actually enacting standards. Perhaps they feel that internally that the courts are doing a pretty good job without them, and so why mess around with it? And they may also lack funding to expand their reach. And that's always a problem with an administrative agency. If the money's tight, surprisingly they're not really excited about expanding their jurisdiction. So the ADA protects those who have a disability or a history or record of a disability or are perceived by others as having a disability. They may not think of themselves as having a disability, but others might. And a disability is defined as a physical or mental impairment that substantially limits one or more major life activities. So it doesn't cover other things that are covered by other types of civil rights acts. It only covers people who actually have a physical or mental impairment that substantially limits one or more major life activities. So the regulations that cover things like physical places of public accommodations, you can look to the Department of Justice 2010 ADA standards for accessible design for those. They're fairly complex. They're also fairly comprehensive. And somebody who has a good firm grasp on construction standards will probably find them fairly easy to understand. So you should hire somebody who's a licensed bonded contractor who is up to speed on your ADA standards to do improvements. That's not guaranteeing, though, that that they will be in compliance. You should consult probably an ADA consultant if you have any doubts. And we saw when we looked at those standards a couple of weeks ago that they're really detailed on certain things. For instance, restrooms, restaurant restrooms or restrooms in any public accommodation, they are really tight. I mean, even the signage, how high the signage is off the floor, what it looks like, whether it's on the door or on the frame to the side, things like that. And they're just a really large number of them. That said, building contractors generally should be familiar with complex codes, and they should be able to deal with this. But that's not always the case. And probably when you're writing a contract, you want to have something in there, a rep or a warranty for ADA compliance, because if you get sued for an ADA violation, you don't want to have to bear all the burden yourself. So that's a big one. And if they balk at it, then that's a good hint that you're not dealing with the best contractor in the world. Maybe you should look further. And then there are virtual places of public accommodations, aka the internet, and so courts have filled the gap. Like I said, the DOJ hasn't promulgated regulations in this area, so courts have, by and large, applied the World Wide Web Consortium's content and accessibility guidelines to fill that gap. We just call them the WCAG or the WCAG, or just the guidelines, I think. And then there are also state laws. I mentioned a couple of them last week. California's UNRU Act, etc. The states tend to gather these under the umbrella of civil rights. So they have sort of umbrella civil rights legislations, and the disability regulations tend to come under those laws. So let's go and look at what happens with an ADA complaint. And what I have in mind here is we have a plaintiff, or a complainant, who, for whatever reason, goes into a place of public accommodation and discovers that the plaintiff isn't able to use some part of that public accommodation, or doesn't have equal access to a place of public accommodation. Maybe there's inadequate seating at the bar, or there is safe for a wheelchair, or in the outdoor area, or person in the wheelchair is unable to find a booth that he or she can sit at with his or her friends. And the list could go on and on. One of the most common violations is that just somewhere in the restroom, the mirror isn't the right height off the ground, or something like that. So here's some common defendants. These are the people who are accused of violating the ADA, and these are public accommodations. Hotels, restaurants, and retail stores, doctors' offices. I highlighted doctors' offices. You'd think doctors' offices would be really in tune with the disabled community. Well, not always. Private schools, why does it not say public schools? Well, they come under Title II. And public schools they're parts of the government, and so they come under Title II. They can all, but you're not going to be running a public school, so you're not worried about that. Factories and warehouses. Surprisingly, warehouses, if they happen to have some publicly accessible function to them. Factories as well. Health clubs, Again, I highlighted health clubs. And they may overlook the fact that the disabled community might want to have access to what they have going. Just because you're in a wheelchair doesn't mean you don't want to do arms. So health clubs can be a problem. And when you start talking about reasonable accommodations for somebody in a wheelchair, it might include a lift to get you, say, from the side of a pool into a pool. So if if you go to your local health club, you might notice that there's a lift there to help somebody get out of a wheelchair and into the pool. So that's considered a reasonable accommodation. Daycare centers, movie theaters, and sports stadiums. I know if you go over here to the Cardinals, the State Farm Stadium here, you'll find there's an entire level that's wheelchair accessible there. And fans can sit with the people in wheelchairs. And then there are various other locations. So, just because you're not on this list doesn't mean you don't have a public accommodation. If you're manufacturing something, but you have a retail store in the front that, you expect occasionally people might come in and place orders and whatnot, you're probably on this list. So here's some common complaints. There's no wheelchair ramp, or the wheelchair ramp doesn't meet specs. It's too steep or it's too narrow. No handrails. Inadequate restroom accommodations. Inadequate or out of spec parking spots. A lot of places you go, it seems like they have more than enough parking spots, but if you go and you measure the grade of their parking lot, you may find that they have more than a 2% grade. That's too steep, and that can be a problem. And the ADA doesn't really take into account the fact that maybe there's been some settling since the parking lot was initially put in. So you could see a complaint based on that. I never thought of this next one, special fees to accommodate disabled persons. I never considered that somebody might charge a special fee, but there it is. It's on the list, and it's a common complaint. So not providing effective communication methods for persons with hearing, visual, or speech impairments. So, you would think these would be fairly obvious, but for instance, if somebody has a hearing disability, you might, let's say you're giving a public speech in an auditorium, you might need to arrange to have a sign language interpreter there or something like that. Again, having hallways or staircases that are too steep or too narrow, and malfunctioning elevator escalator systems that are constantly left out of order. And everybody, if you have an elevator and once in a while it stops working, but you call the technician, the tech gets out there as quick as possible, and it gets taken care of in a timely manner, this is not going to be an issue. If somebody happens to come into your establishment on the day that the elevator is broken, you say, well, it normally is working, and that's fine. However, if they're able to document a pattern of the elevator being out of service, then you may have a problem there. So and kind of an important thing is here, if you're a tenant in a building, some of these things may be not in your direct control. So you're going to want to make sure that your lease has some sort of an ADA indemnification, that those parts of the common grounds that are necessary, for the landlord to maintain are indeed maintained, and they will indemnify and hold you harmless if they don't hold up their end of the bargain there. So so there are two avenues for complaints. One is filing directly with the DOJ, and the other is a complaint filed in court by a complainant. Now, you might think about this a little bit and ask yourself, well, which one would you rather have? And between you and me, I'd much rather have a complaint filed with the DOJ than than in court. There are two reasons for this. Neither one of which has anything to do with whether you'll need a lawyer or not, by the way. Probably will. But the DOJ process could be shorter for a few reasons, and I'll go through those as I walk through this. And I think you'll see pretty quickly as I go through court processes how the fees could stack up and really work to your disadvantage. So a complaint filed with the DOJ, in my thinking here, the likely plaintiff that you're dealing with here, a complainant that files directly with the DOJ, is probably less sophisticated, more concerned about really getting access to your establishment, and perhaps not quite so excited, not as interested in getting a big payday out of the end of it, because and the nice thing here is that there's generally no lawyer involved on the other side. They're DOJ lawyers, Department of Justice lawyers, obviously, but in terms of there being a plaintiff's lawyer who needs to be paid, in a previous lecture, I talked about how one of the things that they can be awarded as damages is the attorney's fees, and they could stack up. So let's look at a complaint filed with the DOJ. The complaint may be filed online, so it's relatively simple to file. And all they really need to do is provide name and contact information, name and the address of the entity that's being complained about, and a brief description of the acts of discrimination, the dates when they occurred, and the names of the individuals involved. And then other information necessary to support the complaint. And what are we talking about there? Well, normally what they're going to do is they should file a formal complaint with the with the business that they're complaining about, and have a copy of that, or at least they should have some contemporaneous notes or something like that they spoke with manager so and so on such and such a date and complained about this particular violation, and they stopped by at a later date and found that it still had not been remediated, something like that. And then they have to tell the DOJ how to communicate with them. So if the complainant needs to provide, if the complainant is hard of hearing, DOJ shouldn't be calling them, but they should be emailing or something like that. So that's what's your basically complainant, what's your preferred mode of communication. So here's some things the DOJ may do when they get the complaint. They may contact the complainant for further information. And a lot of this is probably going to happen before you even become aware that there's a problem, right? You may not get notice of any of this until the DOJ has done some of it. They might refer the complaint to the ADA mediation program. That's probably, if you're the defendant in this case, you're probably, that's probably your best bet for getting things settled quickly, amicably, and less expensively. If it's pretty severe, it might go to the United States Attorney's Office for further investigation. And or if it comes under another federal agency's expertise, they might refer it to that other federal agency for further for further review. If they launch, the DOJ might launch an investigation. They usually, I think, try to do that within a short period of time, and they may consider actually launching their own. It would be a civil suit. It's not a criminal violation, but it's a civil suit in federal court. So those are the various things. Like I said, if there's a valid complaint, you probably would like it to go to mediation, and you should cooperate to the degree you can. And I talked I can pretty much dedicated an entire slideshow to talking about audits and what the importance of having an audit, and probably before you ever get to this point, hopefully you've got an audit and you've got a remediation plan in place. If you're not there, if you put it off, if it just caught you by surprise, or you didn't see my previous presentation, and now you're coming to this at a late date, you can push for that mediation program. The thing is that it's voluntary on both sides. So if the other side is really pushing and doesn't want to do mediation, and really is pushing the department to sue, and the department finds enough evidence that actually makes sense, you might find yourself on the wrong end of a lawsuit. But the mediation program, I feel that the DOJ is going to push them into that mediation program if they can. So that's the good news about filing with the DOJ. The bad news is you're up against the government, and they really have an infinite amount of resources to really go at you. So you cannot take this lightly. It's better than the alternative, I think. You're going to find that you're going to have some, especially if you're a smaller operation, they're not really in the business of trying to put you out of business. They're going to want to, but they want you to take this seriously, and if they feel that you're not, they will do what they have to do to make you comply. So I'll talk a little bit about mediation. Good thing is it's confidential, it's voluntary, it's relatively quick. It's quick, it's quicker than court. And it's most appropriate for things like barrier removal and program accessibility and effective communication. Basically, you'll enter into an undertaking or a settlement decree that says, I realize I got a problem, I'm going to fix it, here's my plan for removing it. If there's a barrier that needs to be removed, this is the time frame I intend to get it done. They will revisit it later on, and if you have violated this agreement, they'll sue you for the violation and for breach of the agreement. Let's see, modification of policies, practices, and procedures. These are things that can be easily changed, easily fixed, easily addressed. Those are the kinds of things that will go to mediation. If you've gotten a lot of complaints before and DOJ considers you to be a recalcitrant sinner, you're headed for court. But if this is your first time, you have a remediation plan, maybe funds were tight or something like that, you didn't get everything done, then, mediation, then, DOJ is going to push for mediation. And that's probably a really good thing for you. If you end up on the wrong end of the investigation, the DOJ may contact you to, first off, let you know that there's an investigation going on, confirm or verify alleged facts. Let's say so-and-so says they came in to your organization and couldn't find a seat that was suitable for them, and they say they complained. Well, if you're the kind of business that keeps good records of those kinds of things, and you you routinely have your managers fill out complaint forms or incident forms and things like that. You can go through and show, well, we never received that. That's the kind of fact that they would be looking for. Or, confirm, yeah, they did complain. But look, we have an audit here from an independent auditor that says that we're in compliance. So, an investigation isn't necessarily the worst thing that can happen if you happen to be in compliance. And if you're not in compliance, there's still an opportunity to either, work in mediation or something like that. They may negotiate directly with you for corrective measures. They may say, look, you've got a problem here. And you might say, yeah, we do have a remediation plan, or, since we got that complaint, we've been working on a remediation plan. This is what it looks like. And they might say, well, I think you should prioritize this over that or something like that. So that, a little back and forth there. In the end, they may file suit in federal district court. Like I said, that's a civil matter. It's not a criminal matter, but it could be very expensive. So let's talk about a civil action. And the only difference between a civil action filed by the DOJ and a civil action filed by an individual is that, the attorney's fees are different. But, this is going to be, I'm going to talk about lawsuit in district court. It could also be in state court if it's filed by an individual. In fact, it probably will be if it's, filed by an individual within that state against, say, business that's only located in that state. It probably will be filed in state court, but the state can enforce federal law as well as its own civil rights laws. So keep that in mind. If it's felt that this has harmed a lot of different people, that the judge might be convinced to title a class action. Those can get big, they can get ugly. The plaintiff class, if it's really large, could be very expensive to compensate. So damages vary, they can be very large. State laws may also be applied, will be, if there are any applicable. And then you've got to worry about attorney's fees. So before civil action is filed, there will probably be some initial contact by the complainant. Somebody comes into your establishment, they find they're not able to find a seat, or they're not able to reach something or something like that, or the signage on the bathroom is wrong, or the mirror is too high, or they can't turn their wheelchair around in the water closet stall, whatever it happens to be. They contact the manager, and the managers should be trained to document ADA complaints, so that when DOJ comes around investigating, you can show, yes, we do, we take these things seriously, we recorded it, and hopefully when you got that complaint, the wheels started turning, you thought, I better do something about this. You contacted a contractor, you worked out some sort of a remediation plan. And, it should go without saying, but maybe it doesn't. Maintain records of all ADA complaints. You're in business, you keep business records. You've got invoices, you've got all sorts of things. You've got leases. Maintain all records of ADA complaints and have them filed in a way that you can find them, because the statute of limitations is a couple of years. You don't want, managers come and go. You don't want to have a situation where somebody complained to Manager X. Manager X made a record, but where did it get filed? That kind of thing. Like I said, have a remediation plan. If you get a complaint, first thing you should be thinking is, how do I fix this? You should never be thinking, oh, he'll go away. Oh, she's just venting. Don't count on it. And, if you get a lot of these complaints and there's kind of a, you have a history of not taking them seriously, that can work against you. parenthetically, if you haven't done so already, obviously, if you've seen my previous slideshows, you know that, you know, you should have an audit done when before you ever open your doors, or if you already opened your doors, as soon as possible thereafter. And you should probably have it updated from time to time, especially for things that are likely to change, such as the slope or grade in your parking lot and things like that, or whether a door always gets stuck, or whether the elevator is habitually broken, things like that. You might receive a cease and desist letter. You might not. They might just go ahead and file a civil suit. But if you get a cease and desist letter, it may include a demand for a settlement of some sort. And it may have a draft complaint attached. And these things they don't have to be in there, but they may be. Don't ignore this. I've had a situation where I served a cease and desist letter on somebody, and they gave me every indication of ignoring it. And all that does is it ticks off the plaintiff and makes them even more determined to sue you. So don't do that. Instead, lawyer up, and get a lawyer on the line, somebody who deals with ADA complaints, preferably, and take this seriously. At that point, if you have already, now when I say prepare a remediation plan, let me be clear here. I should probably put this in the slide. When you lawyer up, your lawyer will probably, if you don't already have a remediation plan, by the time you get the cease and desist letter, your lawyer will probably want to pick an auditor, because that auditor is now going to be an expert, and your lawyer may want to keep the results of that audit as work product, and that can only happen if the lawyer hires the expert. So, up until this point, you should, I think you should have an audit done. I think you should, but by the time you get to this point here, then you need to, get your lawyer on the line, and then don't go out and don't try to fix this thing yourself by the time you get to the cease and desist letter point, because all the communications you have with them at this point are not under privilege unless they come from your lawyer. And there are certain benefits to having your lawyers talk to each other. They can, there's an umbrella of non-admissibility of particular types of admissions and statements and whatnot between negotiating lawyers that you don't get as just a defendant. And I think that's a really important thing, to the degree possible. If you respond yourself to the cease and desist letter, and I really can't, I can't emphasize this enough. If you respond yourself and you don't get your lawyer involved, it is possible that you could create, you could admit some things, or you could, or just, innocent statements statements you think are innocent, could be misconstrued as being admissions of guilt, and you don't want that on the record. So, again, when you have your initial contact with the complainant, your manager should be well trained to document the complaints, and maintain all records. And you should, for goodness sake, if you don't already have a remediation plan, get one prepared. If you have a remediation plan and maybe it doesn't address that particular violation, then you need to get it updated, or at least check with somebody who knows the rules to see, well, was that a valid complaint or not? Because if it wasn't a valid complaint, then having that record of that contact, the fact that you investigated it and found that it was without merit, that's an important consideration. It might lead to a civil action being, well, you might be able to have your lawyer address the complainant in the in response to the initial cease and desist letter and say, hey, look, we have records of the complaint. We have records that that we've had it audited. We've checked with our expert on this, and they say it's not a violation. So, with all respect, we're not settling, and we hope that you'll withdraw your complaint, but we think it's without merit, and we plan to move to have it dismissed out of hand. So if you want to, I'm trying to give you some hints here for short-circuiting the system so that you don't end up in in litigation that you can avoid. So so let's talk about the initial procedure for civil action. The complainant files a lawsuit. You have 21 days to file an answer. This is why when you get that cease and desist letter, if you get one, it's really important that you lawyer up at that point, because you need your lawyer to be up to speed on what the complaint is before they have 21 days to file an answer. And it's not uncommon for a cease and desist letter to go out with a copy of a draft complaint, and that at least gives you a heads up on what the complaint is, and it would give your lawyer a heads up on what their answer needs to look like. 21 days is not a long time. It's surprisingly short, actually, when you consider how long a lawsuit can take. But they're fairly pro forma things. You either deny or admit, each item in the complaint, and then you file. Your answer can be fairly simple, but 21 days, like I said, it's not a lot of time. It's not sufficient time. That is sufficient time. It is not a huge amount of time for your attorney to conduct his or her own investigation. So, and normally extensions aren't granted except, for serious cause. Now, maybe during COVID, you might get an extension, but normally you don't get extensions just because it's inconvenient for you or something like that. So again, lawyer up if you haven't already. If you didn't get a cease and desist letter, or if you did but you didn't heed my advice, well, you better lawyer up now, because you're going to have to admit or deny every fact alleged in the answer, and you're going to have to also put forward your own defenses. And then you can file counterclaims or cross claims. I mentioned earlier, having a clause in your lease that says that the landlord will indemnify you and hold you harmless for any violations that might happen, say, out from the parking lot or something like that. That's not within your control. So you would join them. You would file what's called a cross claim against the landlord to cover those claims. Counterclaims probably won't come up in an ADA action, but you never know. And it kind of depends on whether you've got an ongoing relationship with the individual or not. Okay, and then it will go to a scheduling conference. This is where the court, basically the judge or somebody appointed by the judge will sit down with the parties and figure out, map out kind of a timetable for resolving the lawsuit. And also preliminary motions in this time frame. So preliminary motions might include just a motion to dismiss the lawsuit because it doesn't allege facts sufficient to support the lawsuit, or it could be, any number of other things, maybe maybe bad service or process, that kind of thing. Now, procedure continued. Then we proceed on to discovery and things like document production and interrogatories and depositions. Oh my, these are kind of the this is what eats up a lot of the time before trial. Is each side under the American rule has to participate freely in gathering facts. And this could be, depending on how it comes out of that scheduling conference, this could be a very long period or it could be short. I think courts try to dispose of these things quickly, but no guarantees. There might be some court-ordered inspections or something like that. There will probably be expert reports generated. And again, not to beat that deceased equine too much, but this is where it's nice to have a remediation plan, because you can stick that in there and it makes you look nice. If it goes to trial, it might go to settlement instead, but if it goes to trial, then there will be a trial. It will be a civil trial. It probably won't be 12 jurors. It may be as few as 6 or 8. And then there will be a judgment. And whatever the court says at that point goes. The time frame for this could be anywhere from, if it gets dismissed early, it could be anywhere from, 2 months to a couple, 3 years. So that's the kind of time commitment you're looking at. If you want to balance that out against, doing everything you can right now to comply with the ADA, I think you're looking at doing everything you can to comply with the ADA now being a much cheaper alternative. So, and if you have, if you have to go to appeal, you're probably lost already. But because the law is pretty straightforward. It's there's no question of intent. It's just strict liability. Either you're violating or you're not. And it's pretty much the same thing as if you get a speeding ticket or a parking ticket. Did you violate? Yes. Pay up. That's the way that's going to go. So that's the presentation. It took longer than I thought it would to get through all those slides. But again, if you have any questions, my name is Matt Grumbling. You can email me. You can text me at this number right here. All I ask is that if you do either one of them, give a shout out to the accelerator, so I know I have some frame of reference to understand who's calling and what you're calling about. Okay, so that's it. I'll hand this back.
Thank you. That was great. A lot of information as usual, and information that everybody can find useful, no matter what kind of business you are. So thank you. Now, as I mentioned before, this is the last in the accessibility series. We are going to be taking a little bit of a break from these weekly series right now, but we are planning a great one to kick off the beginning of May. And we will get that on the calendar soon. And Matt, thank you so much. These have been really informative and a lot of good information, and we really appreciate your time.
Well, thank you, Julie. It's been great for me too.
Great. Well, we'll get another one on the books, and remember to check our calendar at the AZTaccelerator.com. Also, if you missed any part of this webinar or you missed any of the series or you just want to watch them again, you can go to the City of Surprise Economic Development Department YouTube channel, and you can find the webinars on there. Well, you have a good rest of the week, and we look forward to seeing you in early May.
All right. You too.
Thank you.
Bye, Julie.